In May 2026, a routine IT maintenance check found that 1.4 million patent assignment records had been hidden from public search, including 450,000 transfers of real active patents, and no one had noticed.
I mean, the sheer scale of those numbers is just, it's incredibly difficult to process.
Right. Welcome to another deep dive, everyone. We are unpacking a staggering hidden failure within the United States Patent and Trademark Office Assignment Database.
Yeah, and this is a system that's designed to be the absolute bedrock of patent ownership. But we now know it has been, well, basically secretly collapsing under its own weight.
Exactly. So we've gathered a stack of sources today, internal memos, technical postmortems, legal analyses to really dissect not just what went wrong, but the existential threat this poses.
And what should truly keep you up at night is the mechanism of discovery here. Like when we see systemic failures of this magnitude in federal infrastructure, we expect them to be the result of, a massive congressional inquiry.
Right, or like a rigorous multi-year audit by the Inspector General.
Exactly, but that didn't happen here. A technician doing routine back-end maintenance just stumbled across it.
Wow, just stumbled across it.
Yeah, there were no flashing system alerts, no fail-safes triggered at all.
That's wild.
And most importantly, there were absolutely no notifications sent to the individuals, the startups, or the massive corporations who paid filing fees. They all just assumed their transactions were being securely recorded.
Okay, let's unpack this. Because if you were sitting there listening to this, you might be an intellectual property litigator.
Or maybe a corporate strategist managing a massive tech acquisition.
Right, or just someone fascinated by catastrophic structural failures in government systems. Regardless of your background, the core tension we have to sit with today is terrifyingly simple.
It really is. The USPTO database systematically hides ownership transfers from the public while simultaneously leaking confidential application data it was explicitly required to protect.
Yeah, which begs the question, if a public database hides what it recorded, what does it actually mean to record anything?
That's the million-dollar question, right? What is the legal utility of a public ledger that the public literally cannot see?
So to really grapple with the magnitude of that, we first have to ground ourselves in how this is supposed to work, like the architectural promise of the system.
Right. We have to look at the legal bedrock. In jurisprudence, we look at the de jure condition, basically, what the law mandates.
The theory of it all.
Exactly. The entire foundation of the USPTO's assignment database rests on a doctrine codified in the Manual of Patent Examining Procedure, specifically MPEP Section 302.
And the concept there is constructive notice, right?
You got it. Constructive notice.
Which is one of those foundational legal pillars that usually operates silently in the background, but it entirely dictates market behavior.
It really does. MPEP 302 essentially establishes that the very act of recording an assignment with the office serves as notice to the entire world.
It's the legal equivalent of a property deed. Like when you close on a piece of commercial real estate and record that deed at the county recorder's office, the whole world is officially, legally on notice.
They are on notice that you are the owner. Yeah.
And it is utterly irrelevant if a competitor never bothered to, drive down to the county office and check the registry.
Right. The law assumes they know because the mechanism for public knowledge was activated. That activation is what creates the legal reality.
But the USPTO's role in that activation is actually pretty constrained, isn't it?
Oh, highly constrained. If we look at Title 37 of the Code of Federal Regulations, 37 CFR 3.54, the law defines the office's function as purely ministerial.
Meaning they are the archivist, not the adjudicator.
Exactly. When an assignment document is submitted, the USPTO doesn't launch some big investigation to verify the underlying validity of the transaction.
So they don't check if the purchase price was fair?
Nope. They don't check if the corporate signatories actually had board approval to transfer the asset either.
So they function like a notary public, basically, just on a massive scale.
That's a great analogy. Yeah, a notary stamping a contract isn't issuing a verdict on whether the contract is legally sound.
Right, or financially wise.
Right.
The stamp simply verifies a procedural reality. This document was presented on this date by these parties.
Precisely. The USPTO's mandate is to take the submission, date stamp it, and place it into the public archive. They validate the existence of the record, not the enforceability of the deal.
And the architecture of that archive is highly specific. When a document is ingested, it gets assigned a very particular coordinate.
Yes, the real and frame number. Even though the system is totally digitized now, the nomenclature still relies on the legacy physical system.
Which used to be literal, right?
Yeah, completely literal. Think of a vast library's microfiche catalog. An assignment would be photographed and stored on a specific reel of microfilm located at a specific frame.
That's so analog.
I know, but today, that reel and frame number acts as the definitive digital coordinate. It's the exact relational database address where that document lives permanently.
And that coordinate is supposed to be your absolute legal shield. Because under Title 35 of the United States Code, Section 261, the stakes are absolute.
Yeah, 35 U.S.C. 261. It dictates that if you fail to record your assignment within 3 months, that unrecorded assignment is void.
Void against any subsequent purchaser, right. Assuming they paid valuable consideration and operated in good faith without knowing about your prior deal.
Exactly. It is the ultimate anti-fraud mechanism.
So, like, if Company A buys a semiconductor patent from a startup, but forgets to record it.
And Company B buys that exact same patent a month later, records it, and had no idea about Company A's deal.
Company B owns the patent. Full stop.
Full stop. The statute exists specifically to compel transparency. It essentially forces the market to broadcast its transactions.
Because without it, the secondary market for intellectual property would just collapse into a chaos of competing secret claims.
It would be a nightmare. Which means, as an operator in this space, your assumption is entirely built on procedure.
Right. I execute a transfer. I submit my assignment document through the USPTO portal. I pay my required fee.
And a few days later, you get an automated notice of recordation containing your official reel and frame number.
My coordinates. I did everything right. I followed the de jure requirements to the letter.
Yeah.
The world should be on notice, right?
Right.
My chain of title is secure and searchable by anyone.
That is the assumption. That assumption is the linchpin of the global IP market. And it's exactly what the May 2026 discovery completely destroyed.
Oh, wow.
Yeah, because we have to transition from the flawless legal theory of 35 U.S.C. 261 to the devastating reality of the USPTO's actual IT infrastructure.
Here's where it gets really interesting. Because the glitch didn't erase the documents, did it?
No, not at all. The documents made it into the building. The recording event happened, but the notice did not.
So what do the technical postmortems call this?
They describe it as an indexing omission divergence. It's basically a fundamental breakdown between the back-end storage repository and the front-end search indexer.
Okay, let's look at the mechanics of that divergence. When you submit the assignment, the USPTO's ingestion engine actually works perfectly.
It really does. It processes the PDF, extracts the metadata, generates the reel and frame number, and deposits the digital asset into the primary relational database.
So your receipt is generated accurately. The record exists in the vault.
Right. But modern web portals don't query the deep vault directly. It would be way too slow. They query an intermediary search index.
And that indexer systematically failed to resolve the links to the vault.
Exactly. It just dropped the connections.
So the portal that every single law firm, every clearance team, and every corporate strategist uses to search patent ownership is literally blind.
Completely blind for 1.4 million records. You can type the patent number into the public search bar, and the system returns a blank result.
It affirmatively tells the user that no transfer has occurred. It's not throwing an error code. It is actively presenting false negative information as authoritative truth.
And we really cannot overstate the gravity of the active assets caught in this blind spot. We're talking about 450,000 hidden records that were non-provisional transfers.
So not just address updates on abandoned applications.
No. We're talking about active, enforceable utility patents changing hands in the open market.
Representing billions of dollars in enterprise value.
Yes. And they have been entirely invisible to the public for years.
Which brings up the most maddening question. How does an enterprise-grade federal IT system fail to notice a discrepancy of 1.4 million records?
Well, in any modern financial architecture, you have reconciliation layers, right? Like a bank's ledger constantly cross-references its back-end storage against the front-end user display.
Right, to make sure everything matches.
Exactly. But the USPTO infrastructure completely lacks an automated reconciliation loop.
Wait, really? None at all?
None. It's a symptom of legacy government contracting and siloed system development. The ingestion engine and the public search portal were likely built in different eras.
Probably by entirely different federal contractors.
Oh, almost certainly. And they're bolted together using brittle middleware. Because there's no active reconciliation loop, the system literally never queries itself.
It never asks, Do the 10,000 records I process today actually show up in tomorrow's search results?
Nope. It operates on blind assumption. Step A completes, therefore step B must have happened.
And it took a manual, routine maintenance check to realize the middleware had been silently dropping connections for years.
Yeah. And the structural rot goes even deeper than just dropping connections. The sources reveal that this fragmented architecture creates bizarre, almost Kafkaesque realities for practitioners.
Oh, like the expungement illusion the memos talk about.
Exactly. To grasp this, we first have to look at the concept of a file wrapper in patent prosecution.
Right. So the file wrapper is the comprehensive official dossier of the application. Every piece of correspondence, every rejection, every submitted piece of prior art goes into it.
And the overarching rule of the USPTO is what goes into the file wrapper becomes the permanent public record.
But human error is a constant. People mess up.
All the time. Occasionally, an applicant's counsel will mistakenly upload a document containing highly sensitive information.
Like an unredacted licensing agreement detailing proprietary royalty structures.
Or an assignment document that accidentally includes the personal home addresses or social security numbers of the inventors.
Oof. So when that occurs, the rules allow the party to file a formal petition to expunge the document from the public record.
You petition the government, point out the error, pay another fee, and they scrub it. That's how it's supposed to work.
Right. But because of the database's fractured architecture, the USPTO doesn't actually delete the asset, do they?
No, they don't. When an expungement petition is granted, the office merely breaks the hyperlink connecting the public search portal to the document.
They don't remove the document from the vault. They just take down the signpost.
That's exactly it. The original, completely unredacted document remains physically sitting on the server at its original reel and frame number.
That is terrifying. So if a third party happens to know those specific digital coordinates,
or if they use an automated scraper that iterates through sequential reel and frame numbers,
they can just bypass the portal entirely, query the backend directly, and pull down these supposedly expunged trade secrets.
Yes. The petition doesn't grant expungement, it just grants security through obscurity.
That is structural negligence. We have a public search portal that is broken in the way that hides critical public ownership data, while the expungement process is broken in a way that permanently preserves and exposes highly sensitive private data.
It is failing in both directions simultaneously.
And that's before we even look at the chronological nightmare of data leaks detailed in the incident reports.
Oh, the timeline of the data overexposure divergence is just a masterclass in compounding IT failures. If we look at the internal logs, we see a pattern of exposure that spans nearly a decade.
Walk us through the leaks, like what exactly was exposed?
Well, starting in December 2017 and running all the way to August 2024. So a period of almost 7 years, a configuration error within the Patent Center exposed the metadata of unpublished applications.
Let's pause on the severity of that. Because by law, a patent application is kept strictly confidential for the first 18 months.
Right. That is the critical window where an inventor's trade secrets are supposed to be protected from competitors.
But for 7 years, unauthorized users could access the titles, owner names, inventor names, and filing dates of these unpublished applications.
Yes. So if a major tech company was pivoting into a new hardware space, their competitors could see the filings immediately.
That ruins the entire point of the 18-month protection.
It does. And the leaks cascaded into other divisions, too. From February 2020 through March 2023, a severe vulnerability was introduced into the Trademark TSDR API.
APIs, or application programming interfaces, are basically how different software systems talk to each other.
Exactly. And when third-party trademark monitoring services queried the USPTO database via this API, the endpoint validation failed to strip out restricted data payloads.
Wait, so what leaked?
The private home addresses of 61,000 trademark applicants were systematically leaked to anyone pinging the API.
Over 3 years. I mean, that's a massive doxing risk.
A 3-year vulnerability exposing tens of thousands of private citizens to doxing, harassment, or corporate espionage.
And the hits kept coming. The sources show that just recently, between February and March of 2024, a separate programming error within the assignment center itself began exposing non-public application titles and numbers all over again.
Right. When you map these failures against the 1.4 million hidden assignment records, a unified theory of the database emerges.
Which is?
Leaking what must be protected via API vulnerabilities and hiding what must be displayed via indexer omissions are not isolated incidents. They are symptoms of a systemic inability to map data governance to IT architecture.
The database fundamentally does not know what it is holding, where it is pointing, or who it is talking to.
Perfectly said. And while the technical postmortems treat this as a data management crisis, the reality on the ground is that this is a litigation nightmare.
Yeah, let's look at the brutal consequences in federal court. Imagine a mid-sized medical device company. They acquire a critical patent portfolio from a failing competitor to protect their flagship product.
Okay, pretty standard scenario.
They record the assignments, pay the fees, and get their reel and frame numbers. 6 months later, a massive conglomerate starts brazenly manufacturing a knockoff of their device.
So the mid-sized company files a massive patent infringement lawsuit seeking injunctions and damages.
Right. Now, what does the conglomerate do?
The very first thing the defense counsel for the conglomerate will do is challenge the plaintiff's standing to sue. They will go directly to the USPTO public portal and run a search on the patent in question.
But because of the indexing glitch, the plaintiff's recorded assignment was one of the 450,000 hidden non-provisional transfers.
So the search result comes back totally blank. The government portal officially indicates that the plaintiff does not own the patent they are suing over.
Wow. So defense counsel takes that printed, timestamped search result to the federal judge and files a motion to dismiss.
Exactly. They argue, Your Honor, MPP 302 requires constructive notice. The official federal database provided zero notice to the market that this plaintiff held title.
We operated in good faith based on the public record. The plaintiff lacks standing.
Yep. The federal government's IT failure is weaponized as the defendant's impenetrable legal shield.
The conglomerate literally steals the technology, and they walk away clean because the system failed to generate a search result.
This is where we reach the critical inflection point of our deep dive today. We are looking at a catastrophic collision between the rigid letter of the law and the fragmented reality of digital infrastructure.
Right, because how does a federal judge or a corporate strategist reconcile the strict de jure promise of constructive notice with the broken de facto reality of a blind portal?
Well, let's debate it, because it's not clear-cut.
Actually, I'm going to push back on the defense counsel's argument here, because I think a strict reading of the law from Section 1 absolutely protects the plaintiff.
Okay, let's hear it.
I've been treating the reel and frame number as the active notice. The office received the document, assigned it coordinates, confirmed receipt. That is constructive notice. The search interface is a convenience layer, not the legal act.
I understand the instinct to anchor your argument in the procedural receipt, but you have to look at the functional mandate of MPP 302. Constructive notice isn't achieved just because a document is resting on a dark server rack in Alexandria, Virginia.
But the receipt proves it's there.
It fundamentally requires the database to operate as a searchable public record. The concept of notice inherently demands that the public has a viable mechanism to be notified. If the index fails to resolve the link, the mechanism is severed and the legal premise of notice collapses. The back-end data is completely irrelevant if the public cannot access it.
But the document exists. The record exists. If I am that medical device company, I have my physical notice of recordation. I can prove the USPTO took my assignment and processed my fee.
I hear you, but...
The legal act of recording is technically and procedurally complete the second they assign those coordinates. The USPTO's failure to build a working UI shouldn't invalidate my federal property rights.
But courts do not operate in a vacuum of procedural technicalities. They operate in the reality of the market. Let's return to the litigation scenario. A defendant searches the official portal and finds nothing.
Right.
You are asking a judge to hold a defendant liable for hundreds of millions in damages for failing to know a fact that the government actively hid from them. If the government's own search tool asserts that you don't own the patent, how can the market be legally penalized for believing it?
I mean, I see the severe litigation risk, absolutely. But procedurally, the reel and frame number is still the anchor. Even if the portal is blind, that coordinate is a definitive address. Shouldn't that be discoverable in discovery? The title transferred.
Think about a county deed office that records your purchase, stamps the deed, files it in the vault, then locks the vault and loses the key. Your deed is real, but your neighbor buys the same property the next week, searches the public registry, finds nothing, and pays full price to the same seller.
Ah, okay. The vault is the USPTO backend. The deed is the reel and frame number.
Yes.
But the search index, the index is the key.
Exactly. And without the key, the vault is useless to the market. The statute might technically say you recorded first, but the practical reality of commercial law dictates that you might as well not have recorded at all.
So it's effectively void in practice.
Recording without indexing is a private fact, not a public right.
Recording without indexing is a private fact, not a public right. Wow. That realization fundamentally breaks the social contract of the patent system.
It really does, because the entire premise of intellectual property is an exchange. You disclose your invention to the public, and in return, the government grants you a publicly recognized enforceable monopoly for a set duration.
If the public recognition mechanism fails, the monopoly is just an illusion.
It is a devastating structural compromise, and knowing this forces anyone operating in the IP space to fundamentally alter their operational posture.
The de jure map is useless. We have to navigate by the de facto terrain.
Precisely. We have to look at what actually works now.
So, what does this all mean? We know the portal is blind. We know the API leaks. We know the legal shield is deeply compromised. We need a strategic map for navigating this broken ledger today.
Let's break this down by the resources at play, starting with what the analysts call the under-resourced player.
Right, so this is the individual inventor, the seed stage startup, maybe the university tech transfer office managing a lean portfolio.
For the under-resourced player, the primary vulnerability is the illusion of compliance. The trap is trusting the USPTO notice of recordation email.
You pay the fee. You get the automated webhook response confirming your real and frame number, and you file it in a folder assuming you were protected under 35 U.S.C. 261.
Exactly. But we now have incontrovertible proof that this email is merely a receipt of ingestion. It guarantees that your document made it into the locked vault. It provides zero guarantee that the indexer actually created the key for the public to find it.
So what is the evasion strategy? A startup doesn't have $1 million budget to hire outside counsel to audit federal databases.
The fix is procedural and costs nothing but time. You must decouple your internal record keeping from the USPTO portal.
Okay, so your internal corporate chain of title must be ironclad.
Yes. But the main operational shift is this. Before you enter any licensing negotiation, before you draft a cease and desist letter, and before you finalize a fundraising round where your IP is the core asset, you must run a direct real and frame query.
We need to clarify the mechanics of this because it's the exact opposite of how 99% of practitioners use the site. Usually people just navigate to the main search bar and type in their patent number.
That is the portal search. That relies on the broken Elasticsearch indexer. To bypass the blind spot, you have to use the advanced search parameters to query the exact physical coordinates.
So you plug in the specific real and frame number from your receipt and query the database directly.
Yes. By pinging the coordinates directly, you are asking the server, show me exactly what is at this address, rather than asking the indexer what documents are associated with this patent number.
Oh, I see. So if the document pulls up via the coordinate query, you confirm its presence in the system.
Right. But if it fails to appear in a general patent number search while succeeding in a coordinate search, you have immediately identified an indexing divergence.
It takes 10 minutes. It costs nothing. And it allows you to identify and petition to correct the anomaly before a defendant uses it to get a patent infringement suit dismissed with prejudice.
Exactly. That's the defensive posture for the lien operators.
But the calculus changes entirely when we look at the well-resourced players. The pharmaceutical giants, the multinational tech conglomerates, the private equity firms buying massive portfolios.
For entities operating at that scale, this glitch actually transitions from a defensive liability into a profound structural advantage.
Really? How so?
To understand how, we have to look at the mechanics of freedom to operate clearance, or FTO.
Okay, yeah. So when a massive corporation is preparing to launch a new product, say a new smartphone architecture or a novel biologic drug, they do not just cross their fingers and ship it.
No, they spend millions on FTO clearance. It is an exhaustive, highly complex title search for patent risk.
Entire floors of attorneys scour the global patent databases to ensure the new product doesn't infringe on existing IP and to map out exactly who owns the patents surrounding their technology so they can negotiate preemptive licenses.
But here is the catch. Standard FTO methodologies executed by even the most prestigious white-shoe law firms rely almost entirely on automated queries run through the USPTO portal.
Or third-party aggregators that ingest the USPTO's public data feeds.
Exactly, which means every standard clearance report generated in the last 5 years is built on a data set entirely missing 450,000 active non-provisional transfers.
That's insane. So by definition, their risk assessment is fundamentally flawed. Standard clearance has a massive, mathematically proven blind spot.
It does. However, firms that are aware of the specific architectural failure The organizations actively listening to the data we are breaking down today can build bespoke, independent verification loops into their FTO workflows.
So they basically abandon reliance on the front-end portal.
Yeah. They utilize direct coordinate scraping, cross-reference against SEC filings, track secondary market broker data, and utilize alternative data sets to map title transfers.
They are essentially mapping the dark matter of the patent universe.
That's a great way to put it. If your biggest competitor greenlights a massive product launch because their standard FTO report came back clean, but your augmented intelligence team knows exactly who holds the invisible patents covering that technology, you have an unparalleled strategic edge.
But that edge is double-sided, because the entities most poised to exploit this dark matter are non-practicing entities, or MPEs.
Yes. The collision of a broken federal database and the aggressive tactics of NPEs is where this situation becomes genuinely dangerous.
Let's look at the NPE business model. Imagine a hyper-aggressive real estate holding company that targets distressed, technically flawed commercial leases. They don't build properties, they don't operate businesses, and they don't care about the community.
Right. They exist purely to acquire the paper rights and ruthlessly enforce the fine print, extracting massive settlements from the actual tenants.
An NPE does the exact same thing with intellectual property. They do not manufacture products or practice the inventions they own. They acquire patent portfolios specifically to monetize them through relentless infringement litigation against operating companies.
And their market saturation is accelerating. The data points from our sources indicate that in Q2 2025 alone, NPEs acquired 45% of all secondary market patent assets.
Wow. 45%.
Yeah. They're dominating nearly half the secondary market, specifically targeting high-yield sectors like 5G wireless technology, advanced semiconductors, and pharmaceutical delivery mechanisms.
And the danger lies in their velocity. NPEs operate with extreme speed. They acquire a portfolio from a distressed tech company on Tuesday, and they are filing infringement suits in the Eastern District of Texas by Friday.
They move exponentially faster than the USPTO's bureaucratic recording lag.
And when you inject a structural failure of 1.4 million invisible records into that high-velocity environment, it's a powder keg.
It really is. It forces well-resourced operating companies into a state of hypervigilance. You can no longer rely on quarterly portal checks to assess your litigation risk.
So you must maintain continuous independent secondary market monitoring.
You have to track the broker networks, monitor the shell companies NPEs use to mask their acquisitions, and maintain unimpeachable corporate records of your own chain of title.
Because the moment an NPE targets your operations, they will aggressively weaponize the USPTO's database failures.
If the index drops your ownership record, they will exploit that omission to challenge your standing or extract a higher settlement.
This has been an incredibly heavy, perspective-shifting deep dive. We started with what is widely considered a rigid, infallible system of legal truth, a digital vault of absolute certainty. And we have unpacked how fundamentally compromised its architecture truly is.
The digital vault is secure, but the map to navigate it has been burning for years.
The shift from blindly trusting the promise of the law to tactically navigating the de facto reality of the software requires a total recalibration of how we manage intellectual property.
It absolutely does.
And as we conclude this session, we want to deliver the exact definitive protocols you need to implement today to survive this invisible ledger. We've reached the closing fork in the road.
The actions you take tomorrow depend entirely on the scale of the resources you manage.
Before you record any assignment, strip every document of personal addresses, social security numbers, and trade secrets, because once that document has a real and frame number, no petition will ever remove it.
Pull your last 24 months of recorded assignments and verify each one with a direct real and frame query, not the portal search, to confirm your ownership transfers are actually indexed and publicly visible.
Those are the immediate tactical steps to armor your portfolio today. But as we sign off, there is a lingering, almost existential question that this systemic failure demands we consider.
It is a question that challenges the very foundation of the knowledge economy. If the core mechanism for establishing who owns what in the patent system is this structurally compromised, if the federal guarantee of public notice is failing on a scale of millions of records, we have to ask, at what point does a failure of public notice fundamentally alter the perceived value and enforceability of intellectual property in the open market?
Something to mull over as you run those direct coordinate queries.
Yeah.
Thank you for joining us on this deep dive. Stay curious, verify your assumptions, and we will see you next time.